Welcome, everybody, or should I say welcome back to the Law of Self-Defense show. I am, of course, attorney Andrew Branker for Law of Self-Defense. We're here to talk. Thank you. Thank you. It's all automated at this point. We're here to talk about Ohio's pending legislation, a House bill to become a self-defense immunity state. In fact, the strongest self-defense immunity state in the country. We started talking about this an hour ago in our previous, an unintended part one show on this topic. And we got about 35 minutes in or so. And the internet here at Law Self-Defense HQ pooped the bed. So that show ended. We were able to scramble pretty quick and set up this part two of that same show. Sorry, folks, we didn't intend it that way. But sometimes that's how the internet works. So I'm not going to start from the beginning all over again. We'll start from basically where we left off. If you're catching this first, this part two first, I would encourage you to pause this, open up another tab, and go look at the part one first. It's 35 minutes of important content that we're not repeating here. All right, let me just take a look and make sure we're streaming where we're supposed to. It looks like we are there. How about on Twitter? The Law Self-Defense member dashboard appears to be working. Yes. And I will leave Rumble. Rumble's working. Oh, no. I will leave Rumble to its own devices. You can never really figure out what's going on. Oh, it is working. All right. So with that out of the way, let's go ahead and launch part two, the unintended part two of Ohio's bold move, strongest self-defense immunity in the country. Here we go. All right, folks, and I wouldn't normally do this midway through a show, but because I had to start all over, I'm obliged to let everyone know that the show is, of course, sponsored by none other than Law of Self-Defense. And the best way to view our content is as a Law of Self-Defense member. Over on our member dashboard on our lawofselfdefense.com site, on the member dashboard, there's a chat function. We only address comments and questions from the Law of Self-Defense members, not on YouTube, not on Rumble, not on Twitter. Also, members get transcripts of every show, downloadable, so they can document their specialized knowledge. They can read the shows if they prefer that to watching lengthy videos or listening to lengthy podcasts. They get their members-only podcast, and of course, there's lots of members-only content that we produce, particularly the most interesting content, which is our breakdown of use of force video content. Every time we put that on YouTube, we get demonetized. It happened yesterday again, folks. So I'm tired of trying. We only do the use of force video breakdowns for our Law of Self-Defense members. The great news is you can be a Law of Self-Defense member dirt cheap. 99 cents gets you a 2-week trial, unlimited access to our members-only content. And if you decide to remain a member after that 2 weeks, the standard membership is only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member. But at the very least, try it out for 2 weeks. You can do that right now. Right now, if you're watching on YouTube, Rumble, Twitter, go to lawofselfdefense.com/trial, open up another tab, become a member right now for 99 cents, join the member stream. You'll get instructions to do that and get your comments and questions answered for today's show, as well as every other show we do during your membership. That's at lawofselfdefense.com/trial. All right, so let's see if I still have my slide deck I was using. It looks like I do, but it started over at the beginning again. So we talked about burdens of proof, burden of production, burden of persuasion. I'm not going to repeat all this, except to note again that in 2019, Ohio had been the last state to put the burden of proof on self-defense on the defendant to prove self-defense by a preponderance of the evidence. And in 2019, they joined the other 49 states to put the burden of proof of self-defense on the state to disprove self-defense beyond a reasonable doubt. The single most important change Ohio could have made in their self-defense laws was this shift of the burden and the shift of the threshold of evidence that's required for self-defense. So kudos to Ohio in 2019, but they didn't stop there. In 2021, Ohio became a stand your ground state. And stand your ground is not the same as self-defense immunity. I need to distinguish these two because they're often conflated and they're completely different things. Stand your ground is what Ohio adopted 2 years ago in 2021. Self-defense immunity is what they're considering now in 2023. Different things. But the terms, again, are often conflated, even by legal professionals. They're often conflated. And I blame you, Florida. I blame Florida, because Florida adopted both of these very distinct legal doctrines at the same time. The same year, the same legislative session, they adopted stand your ground and self-defense immunity. And it's become the practice, even by Florida lawyers and judges, to refer to self-defense immunity as stand your ground, which only creates confusion. It's very sloppy use of legal terminology because these are completely different things. They're not even in the same statute in Florida. Stand your ground is referenced in a number of different self-defense statutes in Florida law. Self-defense immunity is its whole separate thing because it is a separate thing. But to distinguish them, let's first talk about stand your ground. And again, Ohio became a stand your ground state 2 years ago, 2021. So stand your ground effectively redefines what qualifies as self-defense. There's up to 5 elements for a claim of self-defense. By the way, you can get this 5 elements of self-defense cheat sheet for free. We give this away for free, folks, at lawofselfdefense.com/elements. It doesn't cost a penny. It's just a PDF download. It's not nicely printed like this. You'll have to print it yourself if you want a printed version, but you'll get the PDF. Use it however you like. A brief definition of each of the 5 elements of self-defense. If you don't understand these 5 elements, you can't possibly understand self-defense law. These are the building blocks for any claim of self-defense. The good news is there's not 500 of these. There's not even 50 of these. There's only 5. At the most 5. There's usually not all 5. So we're going to talk about that because that's what stand your ground does, is it changes the definition of self-defense by removing one of these elements. So when you have all 5, you have innocence, imminence, proportionality, avoidance, and reasonableness. Innocence, you were not the initial aggressor in the fight. Imminence, the threat you're defending yourself is happening right now. It's either taking place or immediately about to happen. Proportionality, you're not using deadly defensive force unless you're facing a deadly force threat. Avoidance, if you have a safe avenue of retreat, you have a legal duty to take advantage of that retreat before you can use deadly force in self-defense. And reasonableness. First of all, subjective. You have a genuine good faith, subjective belief in the need to use this force in self-defense. And objective. Your belief is not irrational. An objective, reasonable, and prudent person would have shared that subjective belief. When you have all that, you have self-defense. But most states don't require one of these 5 elements. In an otherwise lawful case of self-defense, they do not require the element of avoidance, the element that says, if you have a safe avenue of retreat, you have a legal duty to take advantage of it before you use deadly force in self-defense. 39 states do not require this element of avoidance in an otherwise lawful case of self-defense. So in those 39 states, there's effectively only 4 elements of self-defense. Now, a lot of those states used to require this element of avoidance, used to be a duty to retreat state. So you had 5 conditions to meet for self-defense, but because they got rid of avoidance, now there's only 4 elements. They effectively redefined what qualifies as self-defense because they took away that legal duty to retreat. Those are the stand your ground states. Did I say duty to retreat before? The stand your ground states are the ones that do not require avoidance, do not impose a legal duty to retreat. You can stand your ground, meet force with force, assuming the other 4 elements of self-defense are also satisfied, of course. There are 11 states, now no longer including Ohio, 11 states that do impose a legal duty to retreat before you can use deadly force in self-defense, meaning if you have a safe avenue of retreat, completely safe, you're not required to increase your jeopardy, you're required to take advantage of that avenue of retreat before you can use deadly force in self-defense. There's only 11. It's a minority position in America. But in those 11 states, there are 5 elements. So their definition of self-defense has an additional component that the other 39 states don't have. 2 effectively different definitions of self-defense. One has 4 required elements, one has 5 required elements. That's what stand your ground does. What stand your ground does is reduce the number of requirements from 5 to 4. That's all it does. And all the other elements are still required. So when a state becomes a stand your ground state, it doesn't mean you can shoot someone on a whim. You still have to have been the non-aggressor, the innocent victim of an attack. The attack has to be imminent, taking place, or immediately about to take place. You're still not using deadly force unless you're facing a deadly force threat. And you still have to both subjectively believe, genuinely, in good faith believe in the need to act in self-defense, and that belief has to be objectively reasonable. That's all still required in a stand your ground state. Where avoidance is required, it tends to be a very popular point of attack for prosecutors because it's a very subjective perception. Did the defender have a safe avenue of retreat or not? If he had turned his back, would he have been shot or stabbed in an effort to run? Who knows? Nobody knows what the outcome might have been. So it opens up a door for aggressive prosecutors, persuasive prosecutors to argue to, not very sophisticated jurors that, hey, we think this defendant had a completely safe avenue of retreat and he failed to take advantage of it, and therefore he doesn't qualify for self-defense, convicted, life in prison without possibility of early release. So what the duty to retreat states are saying is you could meet all the other elements of self-defense. You could genuinely, they will concede you were the innocent victim of an imminent deadly force attack that you reasonably perceived. But because they think they can convince a jury that you failed to take advantage of a safe avenue of retreat, they reserve the right to put you in a cage for the rest of your life. What the stand your ground states are saying is, listen, if all those other things are true, if you are the innocent victim of an imminent deadly force attack reasonably perceived and responded to, that's good enough for us. That's lawful self-defense. That's the difference. Now, Ohio, pre-2021, was one of the few remaining duty to retreat states, but in 2021, they became a stand your ground state. They got rid of that element of avoidance. They joined the majority of states. They became the 39th state that was stand your ground, which is great. That's good for defenders, right? I believe stand your ground is the right public policy. I believe if you're the innocent victim of an imminent deadly force attack and you're acting reasonably, that's enough. That's enough for lawful self-defense. I don't think you should be put at the risk that some persuasive prosecutor might convince a jury you could have retreated with complete safety and end up in a cage for the rest of your life. But Ohio did more than become just a stand your ground state, because there's two flavors of stand your ground. There's what I would call standard or soft stand your ground, and then there's hard stand your ground. So I neglected to put into this slide which was which, but I think I have a handy list here of the hard stand your ground states. I do. So I can share that with everyone too. So what's the difference? In a standard, so there's 39, let's see, 1, 2, 3, 4, 5, 6, 7, 8. There's 39 stand your ground states. Of those, 31 of them are soft stand your ground states. So the large majority of stand your ground states are what I would call soft stand your ground states. And in the soft stand your ground states, what a prosecutor is not allowed to do is tell the jury, hey, this defendant had a legal duty to retreat. They violated that legal duty. They lose self-defense. They can't argue that in a soft stand your ground state because there is no legal duty to retreat in an otherwise lawful case of self-defense if you're in a stand your ground state, including a soft stand your ground state. But what the prosecutors in those soft stand your ground states can argue is they can argue, hey, listen, we're a proud stand your ground state. Of course, there's no legal duty to retreat here. But this defendant could have safely retreated, and a reasonable person would have taken advantage of that safe avenue of retreat. And therefore, this defendant's failure to take advantage of that safe avenue of retreat is a failure of the element of reasonableness, because reasonableness is still a required element, even if avoidance is not. And because the defendant fails reasonableness, he fails self-defense, and you should convict and put him in a cage for the rest of his life. It's kind of a backdoor way of attacking a defendant for their failure to take advantage of a safe avenue of retreat, attacking through the element of reasonableness, a flanking attack instead of a direct attack on avoidance, which is no longer available in a stand your ground state. And prosecutors are allowed to make that argument. They make it all the time. And it's sometimes effective, often effective. The hard stand your ground states do not allow this. The hard stand your ground states say that the finder of fact, so the jury in a typical trial or the judge in a bench trial, whoever is the finder of fact is not allowed to even consider the possibility of retreat in evaluating the reasonableness of the defendant's claim of self-defense. So in the hard stand your ground states, this flanking attack on a failure to retreat through reasonableness is not available. And if a jury is not allowed to consider it, a prosecutor is not allowed to argue it because it's an irrelevant argument. So it really takes avoidance completely off the table in an otherwise lawful case of self-defense. Well, when Ohio became a stand your ground state, they didn't just become a stand your ground state. They became a hard stand your ground state. They adopted the strongest version of stand your ground. Way to go, Ohio. First, they put the burden where it belongs on the state to disprove self-defense beyond any reasonable doubt. And then they adopted not just stand your ground, but hard stand your ground. Fantastic. And now we have, sorry, the slide's kind of messed up. This should read self-defense immunity. Now, self-defense immunity, I mentioned stand your ground redefines self-defense, right? Because it changes it from 5 elements to 4 elements, changes the definition of self-defense. Conduct that would not have qualified as self-defense because you failed to retreat under the 5 element, the duty to retreat standard, does qualify for self-defense, is lawful under the stand your ground standard, the 4 element standard, changes the definition of self-defense. Self-defense immunity has nothing to do with the definition of self-defense. Couldn't care less what the definition of self-defense is. You can have self-defense immunity in a 5 element state, in a 4 element state, in a 1 element state. Self-defense immunity does not care what the definition of self-defense is. What self-defense immunity says is if your conduct qualifies as self-defense, however it may be defined in that jurisdiction, you're immune from prosecution and or civil suit. That's all. Has nothing to do with the definition of self-defense. What it does do is it provides an efficient, low cost, less time consumptive, much less risky path to adjudicate a finding of self-defense than if you don't have self-defense immunity. Because what self-defense immunity does for you is allows you as the defender charged with the use of force crime to demand a pre-trial hearing. And in that pre-trial hearing, you get to argue your case of self-defense to the judge. Now, there's no jury because it's pre-trial. You don't have a jury until a trial. So the judge is acting as the finder of fact. It's like a bench trial, but it's a pre-trial hearing. All this is completely normal. You argue your case of self-defense to the judge in this pre-trial self-defense immunity hearing. And if the judge accepts your argument to the required threshold of evidence, we'll talk more about that in a moment, the judge can grant you immunity from criminal prosecution and or civil suit. Now, it varies from state. Some states grant immunity for both. Really, if you want both, you have to have 2 separate hearings, because criminal prosecution, you're getting immunity from the state, and civil immunity, you're getting immunity from a civil plaintiff, and they, each of those is arguing in its own forum. Some states only allow for immunity from criminal prosecution, some only from civil suit. Obviously, I would advocate self-defense immunity should be available for both. But the value of self-defense immunity is this hearing is much less expensive. I mean, it's not nothing. It's thousands of dollars, but it's not hundreds of thousands of dollars, which is the cost of a murder trial. A murder trial, manslaughter trial, you could spend $200,000 before you get to trial. So a pretrial self-defense immunity hearing is much less costly than a full-blown trial. It's much less time consumptive. It's a day or 2 rather than potentially days or weeks. And it's much less risky, because if you lose a trial, you're convicted and off to prison you go. If you lose at the self-defense immunity trial, you don't get immunity, but you still have the opportunity to argue your case at trial. So less risky. You still have a second bite at the apple at the immunity hearing. Now, because Florida, I blame Florida earlier for the reason that people conflate stand your ground and self-defense immunity, because Florida adopted both at the same time. And so when defendants request a self-defense immunity hearing in Florida, it's common to have that referred to as a stand your ground hearing. There's no such thing as a stand your ground hearing on any kind of sensible way. You don't need a hearing to qualify for stand your ground. Everybody qualifies for stand your ground if you meet the conditions of the statute. There's no hearing for that. Self-defense immunity, you have to make an argument to a court in that pretrial hearing. So obviously self-defense immunity hearings are a thing. Stand your ground hearings are not. So whenever you hear someone, and by the way, who makes this what I would say is a terminological error? Everybody. I mean, lawyers in Florida call it a stand your ground hearing. Judges in Florida call it a stand your ground hearing. Everybody calls it a stand your ground hearing, even though, as I've just explained, stand your ground is completely a separate doctrine from self-defense immunity. So don't let yourself be confused by this, okay? Two very different things. Now, I talked a little bit earlier, probably in the part one of the show when it collapsed, about the thresholds of evidence, right? When I talked about the burden of proof, the burden of production, and the burden of persuasion. But there are more, and there we talked about prima facie evidence, a scintilla of evidence. That's what's required to meet a burden of production, more than 0% of evidence, so you can argue self-defense in the first place. And then we talked about the burden of persuasion. And now, with Ohio having adopted the modern standard, in all 50 states, for self-defense, the burden of persuasion is to disprove self-defense beyond a reasonable doubt, and it's on the state. The state has to disprove self-defense beyond a reasonable doubt. But there are other, let's see. There are other standards of proof as well. And I wanted to go over all of these with you. And I apologize, I set these slides up at the last minute this morning, so they're perhaps not quite in the right order, but I'll do the best I can. So again, to remind all of you who may have missed part one, prima facie scintilla evidence, all it is more than zero evidence. There's some actual evidence. It's not mere speculation or imagination. It's not, for all I know, he could have had a gun. That's why I shot him. You had reason to make a reasonable inference that he had a gun. Even if you didn't see a gun, you know that person habitually carries a gun. They told you they have a gun. They reached for the waistband as if they were reaching for a weapon. Some evidence, more than zero evidence, that's sufficient to qualify as prima facie evidence and meet your burden of production and get the legal argument of self-defense in front of the jury at trial, and to get you the jury instruction at the end of the trial. When it comes to the burden of persuasion, half of the burden of proof, whose job is it to persuade the jury of the truth of self-defense? That's beyond a reasonable doubt. And there's no real percentage there. These numbers are just for discussion purposes, but it's the highest level of proof we have in American law, beyond a reasonable doubt. Let's pretend it's 90% of the evidence. And the state has to disprove self-defense beyond a reasonable doubt. So they have to disprove your claim of self-defense by 90%. Now, importantly, this means that the jury could believe, you know what, this probably wasn't self-defense. We believe 75% this wasn't self-defense. And they are obliged to acquit you, because it's not enough for the state to disprove self-defense by 75%. They have to disprove it by 90% in order to get a conviction. Once you've met your burden of persuasion and self-defense is a permitted legal argument, the state has to disprove that claim of self-defense, not just by a majority of the evidence, but beyond a reasonable doubt. And a majority of the evidence would, of course, be a preponderance of the evidence, 50%, a hair above 50%, which is the normal legal standard in a civil suit, right? The plaintiff and the defendant in a civil suit, whoever the jury decides prove their case by more than half, by a preponderance of the evidence, wins the case in a civil case. But in criminal trials, it's generally preponderance of the evidence in order to get a conviction. Now, let's see, there's yet another threshold of evidence called clear and convincing evidence. And there are legal definitions of this, but I didn't want to make the show too technical. For our purposes, it's a kind of vaguely defined threshold of evidence that's somewhere between preponderance, 50%. It's more than preponderance, and it's less than beyond a reasonable doubt. Okay? And it's kind of, so I'm pretending it's between 60 and 80% for our discussion purposes. So different thresholds of evidence for different purposes. And the reason this is important is because Florida, if not the first, was among the first to adopt self-defense immunity. Now, Florida was not the first stand your ground state. California, believe it or not, has been a stand your ground state since the late 1800s. Not based on statute. California doesn't have a stand your ground statute, but from court decisions. California Supreme Court decisions dating back to the 1800s make clear in their law that there is no legal duty to retreat under California law. In fact, the jury instructions to this date, 2023, instruct jurors that not only does the defendant have a right to stand his ground, have no duty to retreat, he has the privilege to pursue his attacker if necessary for his safety. That's CalCrim Jury Instruction 505, if you care to look it up. And you can probably find it if you go to lawselfdefense.com/505. But Florida was, if not the first, among the first to adopt this self-defense immunity provision, which of course is different than stand your ground, as we've discussed. But the Florida legislature did this in a very sloppy way, which is common for legislatures. They do stuff in a sloppy way all the time. The Florida legislature's self-defense immunity law simply said, hey, if it was self-defense, then the person claiming self-defense is immune from prosecution in civil suit. Period. Well, that sounds good, right? Hey, it was lawful self-defense. I'm immune from prosecution in civil suit. But it doesn't tell us anything about how should any of this be determined. Who decides if it was self-defense? By what threshold of evidence? And who has the burden of proving or disproving whatever the threshold of evidence is? The statute said nothing about this. And in a sense, you'd think it's not unreasonable to do that, right? Because it's not the legislature that has to carry out this immunity process. The legislature doesn't go case by case and decide if someone qualifies for immunity. The judicial system does that. The courts do that. So I'm sure what the legislature was thinking in Florida is, well, let's just create the legal privilege. And then the courts, they're responsible judges. They'll decide for themselves what the procedure should be and what the thresholds of evidence should be and what the burden should be. And oh my gosh, did that turn into a complete cluster? Because the courts had no idea how to deal with this. And a lot of the courts, just like we see with the Second Amendment, right? The Bruin decision, Heller, McDonald, the federal appellate courts being in open rebellion against the Supreme Court on Second Amendment issues. Well, a lot of the Florida courts are also hostile to claims of self-defense. Not entirely irrationally. The vast majority of claims of self-defense are nonsense. And that's what the courts experience. So a lot of the courts were hostile to self-defense as a legal defense. And so they were hostile to self-defense immunity. And every trial court now had to kind of decide for itself when self-defense immunity was first adopted. Every trial court had to decide for itself, well, I don't know what to do here. I don't know what the burden should be or who should have the burden or even am I required to have a pretrial hearing or can I wait to decide this until we argue at a trial? So all these different courts in Florida adopted all these different schemes for how to apply self-defense immunity. And then, of course, they got appealed. And then the mid-level appellate courts, of which there are many in Florida, well, they just duplicated that problem. Some of the appellate courts decided the standard should be this. Some decided the standard should be that. And then it had to percolate up to the Florida Supreme Court. And they would make the ultimate judicial decision on how self-defense immunity should work. And it turned out the decisions they came to were less than satisfactory to the legislature. So the Florida Supreme Court had decided, tell you what, self-defense immunity, it does require a pretrial hearing. So trial courts can't just say you have to wait until the trial to make this argument. The defendant's entitled to a pretrial hearing. But the burden is on the defendant to prove self-defense by a preponderance of the evidence. Well, guess what happened? The Florida courts, the trial courts that were hostile to self-defense as a concept, they granted immunity to nobody. Nobody was getting immunity because the courts just say, the judge, I'm not convinced by a preponderance of the evidence this was self-defense. Off the trial we go. And so the Florida legislature saw this and said, well, no, this isn't good. Well, the next way you could do it is say, well, the standard, the threshold of evidence is still preponderance of the evidence, but let's put the burden on the state. That's a little better, but it's not much better, especially if the trial judge is hostile to self-defense. Pretty much have the same outcomes. Nobody gets immunity, no matter how warranted. And the legislature finally got fed up with this and passed a new version of self-defense immunity that did specify some of these issues. In particular, it specified that the burden of proof for self-defense immunity is on the state at that pretrial hearing to disprove self-defense, not by a preponderance, also not beyond a reasonable doubt, which would be the most favorable standard for the defender, right? And that is the standard applied at the actual trial, right? At the actual trial, the state does have to disprove self-defense beyond a reasonable doubt. But the legislature didn't require that for the self-defense immunity hearing, but it did say at the self-defense immunity hearing, the state has to disprove self-defense by clear and convincing evidence. Well, that's better, right? It's better for the defender than preponderance, which was the current standard. It's not as good as beyond a reasonable doubt, but it's pretty good. Clear and convincing evidence. So that was a step forward for Florida. Well, what we're going to see, and the next thing I'm going to pull up, is the actual, now we're finally getting to the Ohio Self-Defense Immunity Bill, HB 233. What Ohio has done, and by the way, when Florida did this, when Florida said the burden's on the state to disprove self-defense by clear and convincing evidence at this immunity hearing, Florida became the state with the strongest self-defense immunity law in the country. No other state was doing this. We'll see in this proposed HB 233 in Ohio. What their self-defense immunity bill is proposing is the heaviest possible burden on the prosecutor in this self-defense immunity hearing. That in this hearing, not only is the burden on the prosecution to disprove self-defense, they have to disprove it in the hearing beyond a reasonable doubt. The same standard they would have a trial, so it doesn't seem unreasonable to me, but a standard no other state has imposed at the immunity hearing stage. And that's what they're proposing. So again, just as with Stand Your Ground, Ohio didn't just adopt Stand Your Ground in the normal flavor, it adopted the most rigorous version of Stand Your Ground, hard Stand Your Ground. What this bill, this self-defense immunity bill, is proposing to do is not just adopt self-defense immunity generally, but to adopt the strongest version of self-defense immunity anywhere in the country for the defender. And that's awesome. And between Ohio, first in 2019, shifting the burden on self-defense onto the state to disprove self-defense beyond a reasonable doubt, like every other state was doing, and then 2 years later in 2021, adopting hard Stand Your Ground. And now 2 years after that, if they adopt this version of self-defense immunity, Ohio will have shifted from being the worst state for self-defense law in the country, the least protections for a defender, to being the strongest state in the country by far for a defender in the case of self-defense. And that, folks, is awesome. And by the way, much of this happened over the vetoes of liberal governors in Ohio. So kudos to the legislature. And I certainly hope HB 233 comes to fruition. All right, so now we're going to jump to the actual bill. Let me pull it up. I'll pull it up on the screen, and then before we actually jump into it entirely, I'll take a look at the comments and questions in the Law of Self-Defense member chat. Remember, folks, we only take comments and questions from our Law of Self-Defense members in the member chat. You can become a Law of Self-Defense member right now. Open up another tab in your browser. 99 cents, folks. That's it. 99 cents for a 2-week trial membership. You'll get immediate instructions emailed to you for how to join this show right now, so you can ask comments, ask questions, make comments that I'll address. As well as, of course, every other show we do during your 2-week period. We do 4 to 5 shows a week at least. And after the 2 weeks, it's still dirt cheap to be a Law of Self-Defense member. It's only about 30 cents a day, a quarter and a nickel a day, less than $10 a month to be a Law of Self-Defense member. Do that right now. Try out this 99-cent 2-week trial at lawofselfdefense.com/trial. So let me take a look at the member chat, see what we have. And apologies again for having to do this in 2 parts, folks. No way for me to control the internet collapsing here at the office, of course, mid-show. I wanted to share the list of the hard Stand Your Ground states. Let me do that first before I do anything else. So we have a standing document for Law of Self-Defense members that tracks the Stand Your Ground states and the remaining duty to retreat states. and the stand your ground states. Law of Self-Defense members can access this at lawofselfdefense.com/retreat. I know the date shows it's several years old, but that's just when we created the blog post. We upgrade the blog post as the law changes. So we have the 11 remaining duty to retreat states. Notice Ohio is crossed out. That's what we do when a state changes status. And these: Connecticut, Delaware, Hawaii, Maine, Maryland, Massachusetts, Minnesota, Nebraska, New Jersey, New York, Rhode Island. Predictably, most of these are blue states. Anti-gun states, anti-self-defense states really are the remaining 11 duty to retreat states. Then we have the hard stand your ground states. I mentioned that there were 8 of those. It's kind of 7.5. Colorado is a hard stand your ground state, not by statute. The statute doesn't say stand your ground, but the Colorado Supreme Court has said, nope, jury's not allowed to consider it. These other states are hard stand your ground by statute. So if you look at the statute, it explicitly says the stand your ground statute, jury's not allowed to consider. Finder of fact is not allowed to consider retreat. Louisiana, Mississippi, Ohio, Texas, Utah, Washington. Wisconsin is kind of a hybrid because Wisconsin prohibits the jury from considering the possibility of retreat if self-defense occurs in the home. Really, this is castle doctrine. So I probably shouldn't even have Wisconsin on this list. Maybe I'll take it off. But outside your home, definitely outside your home, Wisconsin becomes a soft duty to retreat state. All right, so let me pull the bill back up so we're ready to jump into that. And I'll take a look at the questions. Let's see. I'll get to the point where we're back up. Let's see. Well, I hope we're back up. That would be nice. Yep, we are back up. Okay, no substantive questions or comments, I think, that I haven't already addressed. Those of you law self-defense members, you might need to reboot your screen to get the new stream going. Sorry about that. Yeah, so law self-defense members, if you go to lawselfdefense.com/retreat, you'll get that page that I just shared with all of you. This one here. Okay. lawselfdefense.com/retreat. Another benefit of being a law self-defense member is we do aggregate these kinds of legal summaries, and we make them available to our members. 99 cents. 99 cents to try out membership for 2 weeks. And after that, it's still less than $10 a day, folks. All right, so let's dive into this. Now, Representative Williams is the first representative listed here, Josh Williams. As I mentioned at the start of part 1, a week from today, next Thursday, Representative Williams is coming on the Law of Self-Defense show to be interviewed about this bill. Today's show is intended to be kind of a technical legal explanation of self-defense immunity. What I plan to cover with Representative Williams a week from today, August 31st, is kind of the politics and the drivers behind the creation and consideration of this unbelievably powerful self-defense immunity bill. So the bill here says it's to amend 2901.05 of the Ohio Code. That's just Ohio's self-defense statute. And we'll know where the new content, so what they do, if you're not familiar, what legislative bodies will often do is when they're amending an existing statute is they'll have the statute typed out as is, and then they'll strike out the words they want removed, and they'll underline the words they're adding. So what we're looking for is the self-defense immunity provisions, which is what is being added. So let me scroll up until we get to that part. All right, so here's a new part. A person who's accused of an offense that involved the person's use of self-defense, defense of another, or defense of that person's residence. So defense of self, defense of others, defense of habitation. And as I've talked about before, Defensive habitation is not simply defensive property, right? Property can be put into two buckets: least defensible property, items, stuff, unoccupied vehicles, and highly defensible property, homes, businesses, occupied vehicles, structures that serve a function of protective shelter of people. And in defense of highly defensible property, although it might be phrased as if it were defensive property, that's not really what's happening. What's really happening is the property that's protective, that's sheltering, is acting as a surrogate for the people inside. So it's providing an earlier tripwire for justification of the use of deadly force to protect those people inside when they're inside highly defensible property. So when they say here, defense of that person's residence, that's not, you shouldn't be thinking of that as a defense of property provision. All of these, defense of self, defense of others, defense of residence, they're really all defense of persons provisions. So to translate, when a person's accused of some criminal offense based on a use of force in defense of persons, that person, they may file, so it's optional for the defendant, they don't have to, a pretrial motion asserting that they acted in self-defense, defense of another, defense of residence, and requesting that the court establish a rebuttable presumption that the accused person acted in self-defense, defense of another, or defense of that person's residence. Now, this is interesting because I didn't see this before. I'm actually not happy with that sentence. We'll have to see how this develops. What I'm looking for by the end of this is not merely some rebuttable presumption that the defender acted in self-defense. I'm looking for a grant of immunity. A rebuttable presumption would just be something that would be told to the jury at trial for them to consider. Immunity stops the prosecution dead in its tracks. There is no trial. So maybe this is just the first step. Paragraph B. If the accused person described in the paragraph we just read files a pretrial motion, the court shall hold a pretrial hearing. So it's optional for the defender to ask for a self-defense immunity hearing, but if they ask for it, the court has to grant it. So no discretion on the part of the court here. Now, it's good that it's optional for the defendant because a lot of criminal defense attorneys don't want to do a self-defense immunity hearing because it exposes their trial strategy to the prosecution, and then the prosecution can optimize their arguments to defeat the claim of self-defense. So there are plenty of criminal defense attorneys who, even if they're given the option for a self-defense immunity hearing, don't want to take it. So you wouldn't want to compel the defense to have to undergo a self-defense immunity hearing. You want it to be optional. This legislation, this bill does that, makes it optional. But if they exercise the option, the defense does, then the court has to grant the hearing. If at the pretrial hearing of the person accused, there is evidence presented that tends to support by a preponderance of the evidence that the accused person used the force in self-defense, defense of another, defense of that person's residence, the court shall grant the pretrial motion. I'm not sure what the pretrial motion is here. There's a hearing. What's the pretrial motion? Is that the motion to create a rebuttable presumption? All right. So if the defender in this pretrial hearing shows by a preponderance of the evidence that it was self-defense, the court shall grant the motion for a presumption that it was self-defense, a rebuttable presumption. So a presumption that the state can still overcome. Now here, what we're looking at is the burden is on the defense to prove self-defense at this stage by a preponderance of the evidence, which is what the standard used to be in Florida for immunity. Let's see. Now continuing, if the court grants the pretrial motion at the trial of the accused person, there shall be a rebuttable presumption the accused person acted in self-defense, defense of persons. The prosecution has the burden to rebut this presumption by proving beyond a reasonable doubt that the accused did not use the force in self-defense. You know, I'm sorry to say this, this immunity, this is not as good as I would have liked. When I saw this, when I scanned it, I saw this burden on the prosecution to prove by beyond a reasonable doubt that it was not self-defense. And I thought that was what was being applied in the immunity hearing. It looks like it's only being applied at trial which is the standard of trial anyway. So this is not really giving the defense anything. I mean, except I guess the jury gets to hear there's a rebuttable presumption, but it doesn't change the burden on the state. Even without the rebuttable presumption, the state already had the burden of disproving self-defense beyond a reasonable doubt. So this bill doesn't change that, doesn't make the defender's position really stronger, except for this kind of talking point about a rebuttable presumption that they acted in self-defense. But the truth is, folks, and properly argued, it's already presumed that you acted in self-defense, right? If you're charged with a crime, you're presumed innocent until proven guilty beyond a reasonable doubt. It was self-defense until the state disproves self-defense beyond a reasonable doubt. It's presumed it was self-defense. And that is a rebuttable presumption. The state can overcome it if they disprove self-defense beyond a reasonable doubt. But that exists independent of this bill. That's already the law in Ohio and in every other state. Continuing, if the person who's accused does not file a pretrial motion, or the person files a pretrial motion, but the court denies the pretrial motion, at the trial of their accused, there is no rebuttable presumption that, oh, I see. So if the person accused does not request the motion of a rebuttable presumption, or the state has the hearing, doesn't believe self-defense was proven by a preponderance of the evidence, and so denies the motion, doesn't grant the rebuttable presumption, then there shall be no rebuttable presumption that the accused person acted in self-defense or defense of persons. However, at the trial, the person is not precluded from asserting that they acted in self-defense. So again, you get that second bite of the apple, even if you to argue self-defense, even if you lose at the pretrial hearing. Let's see. If the accused person asserts they acted in defense of persons, and if at the trial there's evidence presented that tends to support by a preponderance of the evidence that they used force in defense of persons, the prosecution must prove beyond a reasonable doubt that they did not use force in self-defense. Well, this is all this stuff that's not underlined. That's already the existing law in self-defense. And all this is existing law. None of this changes definitions of dwelling, residence, vehicle. So this is kind of a hybrid. It's not as good as I thought it was. I thought the standard was going to be at the self-defense immunity hearing that the state had to disprove self-defense beyond a reasonable doubt at the hearing. Again, in Florida, you have to disprove self-defense by a preponderance, by clear and convincing evidence, this standard, which is better than this standard. But the best would be if you required the state to do it, it would have to do a trial anyway. Disprove self-defense beyond a reasonable doubt. And I think that should be the standard. Because if the state cannot do that at a pretrial hearing, why would we think they could do it at trial? It's like, imagine if these were high jumps, right? And to win the track and field meet, you have to be able to jump over beyond a reasonable doubt. But in all your practice, the highest you can ever jump is by clear and convincing evidence. Why would anyone think that athlete's going to be able to win the match, win the meet? Right? If I were the coach and I knew what the standard was and I wanted a reasonable expectation of my team winning the meet, I'd want to see my athletes in practice clearing beyond a reasonable doubt. The analogy would be the law should require that the prosecution meet the standard at the pretrial hearing that they're going to be required to meet at trial. That would be what I would like to see. And this rebuttable presumption language that's being used here is kind of weird. I don't see that in other self-defense immunity statutes. So this isn't actually a self-defense immunity statute. It's like a rebuttable presumption statute. Now, rebuttable presumptions in self-defense law, use of force law, are not unusual. They're commonly applied in the context of defense of highly defensible property. So there's many states where if the defender is defending against an intruder into highly defensible property, which always includes your home, may include your business, may include an occupied vehicle, that if those are the facts, that there was someone unlawfully and usually forcibly attempting to enter your highly defensible property, the law creates a legal presumption that you had a reasonable fear of imminent deadly force harm. And that's told to the jury at trial. Now, that legal presumption gives you 3 of the 5 elements of self-defense. It creates a legal presumption of a reasonable fear of imminent deadly force harm. That's reasonableness, imminence, and proportionality. And because it's highly defensible property, especially your home, at least, you get the benefit of the castle doctrine. So even if there would have been a legal duty to retreat in one of the 11 duty to retreat states, you're relieved of that duty under the castle doctrine in your castle. So avoidance goes away too. So the effect of these legal presumptions in the context of highly defensible property is to take away or to presume that they're checked off 4 of the 5 elements of self-defense. The only one left is innocence. And it's kind of baked into the cake that you're the innocent party if you're dealing with an intruder into your home. So really, the legal presumption is giving you everything you need to justify your use of deadly defensive force against a unlawful, forcible intruder into highly defensible property. I'm a big fan of those legal presumptions. What this is doing is creating a similar legal presumption, but instead of being triggered by the facts of an intrusion into highly defensible property, it's being triggered by this pretrial hearing. But as near as I can tell, what this pretrial hearing is not doing is giving you immunity. It's not a simple grant of immunity. It's simply giving you another argument you can make to the jury at trial. So you're still going to trial. It's not relieving you of the cost or time or burden of a trial. If I'm reading this correctly, I'll be very interested in discussing that with Representative Williams. Now, I hadn't planned on doing this, but let me see if I can pull up so you can get a contrast in this. Whoops, that's not what I want to do. A contrast with Florida's. Let's see, 776012. See if I have the current version of the statute conveniently available on the Law Self-Defense server. Let's see. No, that's not the... Stupid Florida lawyers sent me to the wrong statute. 032 is the correct statute. Okay. I can do that too. Just so you can see a contrast in how these statutes are phrased, or the Ohio bill versus the Florida statute. The Ohio provision is not yet law. Yes. Okay. So let me pull this up. By the way, that little thing on the right is how to get a free copy of our best-selling book, The Law of Self-Defense Principles, real physical book, folks. You can see the reviews on Amazon for our books. They're 5-star rated, well over 1,500 reviews, but don't buy it on Amazon. Amazon will charge you $25 for the book plus shipping and handling. We only ask you cover the cost of the shipping and handling. We'll eat the cost of the book, and you can get this at lawofselfdefense.com/free book, as shown there on the right. Now let me expand this so we can actually read it. Okay. So this is the Florida Self-Defense Immunity Statute. 776032. It's even entitled Immunity from Criminal Prosecution and Civil Action for a justifiable use or threatened use of force. So get the immunity. It's not a get out of jail free card, folks, right? If it was a bad shoot, it's a bad shoot. If it wasn't legally self-defense, you don't get the immunity. In fact, off to prison you go. but it reads, a person who uses or threatens to use force as permitted under Florida's use of force law is justified in such conduct. I mean, that's if you meet the conditions for privileged justified use of force, you're justified. And such conduct is immune from criminal prosecution and civil action. So you're getting both. For the use of threatened use of force by the person who attacked you or their family or heirs in a wrongful death case, against whom the force was used or threatened. And then they have some carve-outs where you don't get the immunity. So if you used force against a law enforcement officer in the course of his duties, it doesn't mean necessarily you can't argue self-defense, but you don't qualify for a self-defense immunity hearing. As used in the subsection, the term criminal prosecution includes arresting, detaining in custody, and charging or prosecuting the defendant. Paragraph 2, a law enforcement agency may use standard procedures for investigating a use of force event, but the agency may not arrest the person unless it determines there's probable cause that the force that was used or threatened was unlawful, that it wasn't self-defense. The court shall award, that shall is important. A lot of states have this provision. The court shall award reasonable attorney's fees, court costs, compensation for loss of income, and all expenses incurred by the defendant in defense of any civil action brought by a plaintiff if the court finds that the defendant is immune from prosecution. This is a really important provision, folks, because it enacts a cost for a plaintiff to bring a civil suit against you for you using force against them if there's a prospect that you're going to win self-defense immunity. Without this kind of provision, a criminal attacks you, you defend yourself, you injure them or kill them, and they're sitting in jail or they're in the morgue. They got nothing better to do, or their heirs, the surviving family has nothing better to do. May as well just file a civil suit against you, see what happens. Maybe they'll make a bunch of money. Unless the risk of filing that civil suit means that if they lose on the immunity hearing, they have to pay all your legal fees and other costs. So if they lose, it's not just a contingency basis litigation anymore. You know, contingency is when it's an injury case and a lawyer comes to you and says, hey, let me argue your case, and unless I win you money, you don't have to pay anything. Here, lawyer comes to you and says, hey, let me sue that guy who shot you in self-defense. And if I don't win you anything, you don't have to pay me anything. Well, here, if you lose, you do have to pay. Because you have to pay the defenders legal costs and other fees. And this shall is really important. I mentioned this at the start. A lot of states have this provision in their self-defense immunity law, and it says may. The court may award these fees and costs. What do you think the courts tend to do when it's an option for them? They don't award. So the shall here, one word, huge difference. Now the plaintiff, who was the aggressor in the physical fight, is definitely on the hook. Assuming, of course, they have any money to take. And 4, in a criminal prosecution, now this is where the Florida legislature, this was added relatively recently, this is where the Florida legislature got tired with the courts saying the burden's on the defendant to prove self-defense by a preponderance of the evidence at the immunity hearing. Nobody was getting immunity. And the legislature got fed up and said, nope, we're changing the legal standard by statute. And this is binding on the courts. The new legal standard is not the defense has to prove self-defense by a preponderance at the immunity hearing. The new standard is the state has to disprove self-defense by clear and convincing evidence. And it reads, in a criminal prosecution, once a prima facie claim, that's that more than 0% of evidence claim of self-defense immunity from criminal prosecution has been raised by the defendant. So that's kind of the burden of production for the immunity hearing. At a pretrial immunity hearing, the burden of proof by clear and convincing evidence is on the party seeking to overcome the immunity. Well, that would be the prosecution from criminal prosecution provided in this statute. So the Florida self-defense immunity statute, it's not granting merely some rebuttable presumption that would carry over to trial. It grants immunity from prosecution, period. The whole prosecution effort stops right there. There is no trial. And the Ohio bill doesn't appear to do that. The Ohio bill appears to create a rebuttable presumption, much like the rebuttable presumption you get if you're defending yourself against a unlawful, forcible intruder into your home, which is a nice thing to have, but you're still going to trial. So the hundreds of thousands of dollars in cost, the months of preparation, and maybe weeks of trial, and the risk of getting convicted and going to prison. There's always a risk. I don't care how innocent you are. If you're in front of a jury, there's a risk of getting convicted. All of that is still incurred, it appears to me, under the Ohio bill, when it would not be under the Florida bill. Under the Florida bill, if you win that hearing, that pretrial hearing, you're not going to trial. It's over. And if you win the pretrial hearing in a civil context where the plaintiff gets to argue it wasn't self-defense, you get immunity from civil liability, period. Ohio doesn't appear to do that in their bill. So I'd be interested in discussing that with Representative Williams on Thursday, a week from today. I presume there's political reasons why they didn't push more aggressively on this HB 233, but Representative Williams will, I'm sure, be happy to share with us what their thinking was on all of that. All right, let me turn back to the member chat and address questions and comments there. Again, folks, the chat, the comments and questions we address are only for Law of Self-Defense members, not on YouTube, not on Twitter, not on Rumble. You need to be on the Law of Self-Defense member stream with the chat window. Put your comments and questions in there. You can only do that as a Law of Self-Defense member, but you can become a Law of Self-Defense member right now. Open up another tab, go to lawofselfdefense.com/trial, become a trial member for 99 cents, 2-week trial membership. And if you stay a member after that, it's only 30 cents a day, less than $10 a month to be a Law of Self-Defense member. Let's see what we have here. I'm going to refresh the page just because we've had some glitches today. Okay. Lots of members talking about jury duty, getting jury duty, not getting jury duty. Yeah. Right, and there's no reference to civil matters in the Ohio bill. Yeah, maybe Representative Williams will be amenable to strengthening the bill once we've brought these issues to his attention. There's more on the table to go for. Maybe they've considered these issues and it's just politically untenable. I don't know. That obviously I wouldn't be in a position to evaluate that. Representative Williams certainly would be. Let's see. Law Self-Defense member Zachary asks, how's the fight to get Kyle's law enacted going? Well, I don't do legislative fights, folks. I'm not in the legislature. I'm just a small town lawyer. So I proposed Kyle's law for actual legislators to consider. My view of Kyle's law is it's almost kind of a turbocharged version of a self-defense immunity law. Just like the immunity law, like this one in Florida that says you shall be awarded attorney's fees and all that from a plaintiff if you're sued in civil court, but you win in the immunity hearing. It puts teeth, it puts a cost, a risk in there for the defendant. I think there should be skin in the game for a prosecutor. A prosecutor knows when he brings a prosecution in a self-defense case that at trial, he's going to have to disprove self-defense beyond a reasonable doubt. Let me pull up my little chart here again. This is the right-hand column. That's how much evidence, 90% evidence for purposes of discussion. That's how much evidence a prosecutor needs to disprove self-defense and win an acquittal at trial. My question would be this. If we get to the end of the trial and the jury goes into deliberations and they decide that the prosecution failed to meet that 90% effort requirement, not by a little, but by a lot. If the jury, when asked, were to decide, you know what, the prosecution didn't even get to 50%, much less 90%. I would have a special jury verdict form that asks the jury that question. Do you believe the state has failed to disprove self-defense by even a preponderance of the evidence? And if the jury says, yes, the state's failed to do even a preponderance of the evidence, when they know the standard's supposed to be beyond a reasonable doubt, I would hold the prosecutor personally responsible for that defendant's legal expenses. It comes out of his personal wallet, because no prosecutor should be bringing a case against a defender knowing that the standard is disproving self-defense beyond a reasonable doubt if the best they can do at trial is not even a preponderance of the evidence. And any responsible prosecutor should be able to distinguish between those two, not just take a shot at it, because the way the standard is today, if the prosecutor brings you to trial and shows up with only 10% evidence or 0% evidence against self-defense, because that's what happened in the George Zimmerman trial. I watched every minute of the George Zimmerman trial. The prosecution had zero evidence inconsistent with self-defense. The same with the Kyle Rittenhouse trial. Zero evidence inconsistent with self-defense. Zero credible evidence. And yet it cost the prosecutor nothing in those cases. Angela Corey, no consequences for her. Binger, no, and Rittenhouse, no consequences for him. So there's no downside. It becomes a win-win scenario for the prosecutor to take you to trial. Because either he gets the conviction, and again, innocent people get convicted all the time. There's always a risk of conviction. Just because you're convicted doesn't mean you were actually guilty. It just, it's like a football game. On any given Sunday, even the worst team might win. Otherwise, we wouldn't bother playing the games. So in any given trial, even a bad prosecution might get lucky, might win. Juries are dangerous and unpredictable creatures. There's political dynamics away. Maybe it's a racially energized case and it just becomes a railroading. And I don't think any prosecutor should put a defender at those kinds of risks if they can't even bring to bear a mere preponderance of the evidence against self-defense. If they do that, I think they should be held politically accountable, because if there's no cost, they just do it. They win it, they get a conviction. And if there's no conviction, if it's an acquittal, they still win in terms of political capital. I mean, you don't score any shots you don't take, right? That's going to be the prosecutor's attitude. So they're incentivized to bring prosecutions even in very weak cases where the evidence is overwhelming it was lawful self-defense. They can still bring you to trial, and they should not be able to do that and not bear a consequence for doing that. That's what Kyle's law is about. But I'm not a legislator, folks, so I don't argue that. I just propose the idea, and it's up for actual legislators to pick up the ball. If you'd like to learn more about it, by the way, I do have specifics on it. Let's see. Where can people find that? If I have a shortcut URL. No, that's not it. Let me try this. Yeah, if you go to lawofselfdefense.com/Kyle's Law, no apostrophes, just Kyle's with an S law, it'll take you to my proposal for that legal provision. And I know some actual legislators have proposed similar things. I don't know if it's based on what I had written up or if they came to the concept independently. I'm not sure. Let's see. Law self-defense member Tony says, Kyle's law would effectively strip the prosecutor of absolute immunity. Yeah, I don't think prosecutors should have absolute immunity. I mean, in some senses, they don't. There's like a 1% chance a prosecutor might be held accountable for misconduct. But I think the risk should be more substantial. I mean, these are very powerful positions, and the punishment they can inflict with the process itself, even in the absence of a conviction, is absolutely destructive to the defender. So yeah, I think there should be a greater risk that they'll be held accountable for misconduct than 1%. That's my position. No one has to be a prosecutor, right? If you feel the risks are too great, if you feel your judgment is going to be that bad that you might be held accountable, well, too bad. Don't take the job. Don't take the job. All right, folks, I think those are all the comments and such that I had. So with that out of the way, between part 1 and part 2, we're back at like an hour and 40-minute show. I like the sound of my own voice, I guess. All right, folks, that's all I have for all of you today. Tomorrow, what are we doing tomorrow? Let me see. So I can give you a heads up. Tomorrow, we are doing, let me pull it up here. Tomorrow we are doing this. Oh, that little tab covers up the title. You know what? I have to talk to our graphics people about that. That's not so good. Tomorrow we're talking about Alec Baldwin. So Alec Baldwin, of course, was he killed Helena Hutchins, a cinematographer on the set of the movie, low-budget movie Western Rust in New Mexico. He did that by pointing a revolver at her and killing her with it, without obviously ensuring first that it was not unloaded. Obviously, if he had done that, there would have been no rounds in the gun. She would not have been shot and killed. It's always been my position, and it's not a complicated argument. This is involuntary manslaughter under New Mexico law and the law of every state. If you point what you know to be a real gun, and he says he knew it was a real gun, at another human being, and it discharges and kills them, you created, by pointing that gun at them without ensuring first it was unloaded, you created a substantial and unjustified risk of death to another person, ignored that risk, the death results. That's the definition of reckless manslaughter, involuntary manslaughter. Nobody would believe for a moment that Alec Baldwin, that this had been a suicide scene, that he would have pointed that gun at his own head, that real gun, what he knew to be a real gun, at his own head without ensuring, or the head of his wife or children, without first ensuring that there were no rounds in the gun, right? And he failed to do that for Helena Hutchins, killed her as a result, involuntary manslaughter. And I have detailed arguments on this that I've made since the day after the event that I'll be sharing with you in this show tomorrow. The reason we're doing the show tomorrow is that although this past April, although Baldwin was originally charged with manslaughter by New Mexico prosecutors, this past April, those charges were dropped for what I can only presume are political reasons, not for legal merit, but they were dropped without prejudice. So they were dropped with the option for the prosecution to bring them back. And another person charged with manslaughter in this case has been Hannah Gutierrez Reed, the armorer, very young female armorer on the movie set of Rust, who is responsible for the firearms. She's being charged with manslaughter because she did not ensure there was no live ammo on set to get into the gun. Different legal arguments about that case, but she's about to go to trial. And there's been some court filings in her case, particularly a firearms examiner report saying that the gun in Baldwin's hand could not have discharged without the trigger being pulled. Impossible, this report says. That has raised some eyebrows about Alec Baldwin's, again, manslaughter liability. And one of the things the Gutierrez Reed defense is saying is that because Alec Baldwin had to have pulled the trigger, and by the way, we have imagery of Baldwin in the moments before the shooting practicing drawing the gun, and every time he does it, he's got his finger on the trigger. But the Gutierrez Reed defense team is saying, hey, if he pulled the trigger, that's an intervening cause between our client's misconduct, alleged misconduct, not ensuring there was no live ammo on set. It's an unpredictable intervening cause that she could not have foreseen, that he would point a gun, or what he knew to be a real gun, at a woman, at Helena Hutchins, and actually pull the trigger on her with the muzzle pointed at her. Gutierrez Reed could not have predicted he would do that. And as this kind of unpredictable intervening cause, that cuts off her liability for the death. It's a legal argument the defense team is making. And because they're making that argument that Baldwin was the intervening cause, it raises again the question of, well, who really was responsible for the death of Helena Hutchins? Was it really the armorer? I mean, surely she should have civil liability, but should she have criminal liability for manslaughter? Or should it really be Alec Baldwin? And in responding to the Gutierrez Reed defense team, the prosecutors have said, listen, all this intervening cause stuff, we're still reserving the right to prosecute Baldwin. In fact, we're going to make a decision within the next 60 days. So we're still thinking about bringing charges against Alec Baldwin. So we're going to talk about all of that in tomorrow's show. That's tomorrow, August 25th at noon Eastern time. And if you go over to our YouTube channel, you can click the little notify me button there. Just go to youtube.com/law of self-defense. Or if you're a member, of course, it'll be in the member stream and so forth, as we usually do. So just to give you a heads up on what's coming tomorrow. All right, folks, with that out of the way, Again, I'm attorney Andrew Branca for Law of Self-Defense. Thank you so much for being here. We couldn't do any of this without your generous support, particularly you Law of Self-Defense members. And I just want to remind all of you that if you carry a gun, if you carry a knife, if you carry pepper spray, if you practice jujitsu so that you're hard to kill, and I do all those things so that I'm hard to kill, so that my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Not by learning legal tricks. We don't teach legal tricks here at Law of Self-Defense. We teach the actual law of self-defense based on actual law. Know the law of self-defense so you know where the legal boundaries actually are. And that also enables you to act more decisively in self-defense because you've already worked out what the legal boundaries are. You don't have to worry about that in the crisis of the moment. You can focus on the actual fight. Winning that fight is the most important thing. All right, folks, until next time, until tomorrow, talking about Alec Baldwin, I remain attorney Andrew Branca for Law of Self-Defense. Stay safe.